Have you ever wondered why a company can stop someone from copying the exact shape of a tractor panel or the exact arrangement of circuits inside a tiny sensor chip, even when the underlying invention itself is already known? That's the fascinating world of design and layout protection. In today's session, we're going to go through designs and layout rights in agriculture and biotechnology, and we'll build our understanding around two important pieces of Indian law: the Designs Act 2000 and the Semiconductor Integrated Circuits Layout Design Act 2000. This is one of those topics that comes up quite often in your IPR exams, so pay close attention, and by the end of it, you'll be able to explain both acts confidently with examples. All right, let's get into it. Let's begin with understanding Introduction to Designs and Layout. The first point here says, intellectual property rights, IPR, protect creations of the mind, inventions, literary works, artistic works, symbols, names, images, and designs. Right, so IPR is really an umbrella term, and design is just one branch under that umbrella. Moving to the next point, design protection covers the ornamental or aesthetic aspects of a product, its shape, configuration, pattern, or ornamentation. So notice the word aesthetic here. This is the key idea we'll keep coming back to. Another important point is layout design, topography, protects the three-dimensional disposition of semiconductor integrated circuits. In simple words, this is about how components are physically arranged inside a chip. Next up, in agriculture and biotechnology, design and layout rights protect innovations ranging from novel seed packaging to microchip-based precision farming tools. You see, this shows how these two laws are actually quite relevant even to farming. Then we have India's key legislation, the Designs Act 2000 and the Semiconductor Integrated Circuits Layout Design Act 2000, two separate acts for two different kinds of subject matter. And finally, these rights encourage innovation by granting creators exclusive rights to use, license, and commercialize their designs. That's essentially the whole purpose of this branch of law, to reward original creators. Now let's look at definition of design. Under legal definition, it says, under the Designs Act 2000, India, design means only the features of shape, configuration, pattern, ornament, or composition of lines or colors applied to any article, whether in two-dimensional or three-dimensional, or in both forms by any industrial process or means. This is a pretty important legal definition, so students, this one is worth remembering word for word if it comes up in your exam. Under key elements of design, the first one is shape and configuration, then pattern and ornamentation, then composition of lines or colors, then applied to an article by industrial process, and finally must be novel and original. So 5 elements in total, and notice that novelty is the last but a very essential requirement. Now, under what design does not include, the first exclusion is any mode or principle of construction or anything which is in substance a mere mechanical device. Second, trademarks, property marks, or artistic works as defined under Copyright Act. And third, features of shape dictated solely by the function the article has to perform. So basically, if something exists purely because of function and not appearance, design law will not protect it. Building on that idea, let's compare design versus function. This is presented as a table, so let me walk you through the important rows. Under focus, design protection deals with aesthetic appearance, while functional or patent protection deals with technical function and utility. Under governed by, design is governed by the Designs Act 2000, whereas function is governed by the Patents Act 1970. Under protects, design protection covers visual or ornamental features, while patent protection covers the inventive concept or process. Under duration, design gets 10 years, plus a 5-year renewal, whereas a patent gets 20 years. Under registration, both require mandatory registration for protection. And under example, the shape of a tractor body panel falls under design, while the engine mechanism of a tractor falls under patent. And under agricultural use, design covers packaging, tool appearance, while patent covers the seed treatment process. And there's a nice one-line takeaway given here. Key principle: design protection covers how a product looks, patent protection covers how a product works. This single line is actually a favorite exam question, so do keep it in your notes. With that in mind, let's move to layout design topography. Under the heading Semiconductor Integrated Circuits Layout Design Act 2000, the first point is layout design, topography, refers to the three-dimensional disposition of elements of a semiconductor integrated circuit, IC. Second point, protects the original arrangement of transistors, resistors, capacitors, and interconnections on a chip. Third, governed by the Semiconductor Integrated Circuits Layout Design Act 2000 in India. And fourth, based on WIPO Treaty on Intellectual Property in Respect of Integrated Circuits, Washington Treaty 1989. So this act traces its origin to an international treaty. That's worth noting. Now, under the heading Relevance to Agriculture and Biotechnology, the first application is Precision Farming Sensors and Microcontrollers, IC layout designs used in soil moisture sensors, GPS trackers, and drone navigation chips. Second, biosensors for pathogen detection in crops use proprietary IC layouts. Third, smart irrigation controllers rely on custom chip designs protected under this act. And finally, protection duration, 10 years from data filing or first commercial exploitation, whichever is earlier. Can you relate this to a real-life example? Think of any smart irrigation system you might have seen. The chip design controlling it is exactly what this act protects. Let's shift our attention to legal framework. Under the Designs Act 2000, the points are repealed and replaced Designs Act 1911, protects industrial designs for articles, registration with controller of patents, designs, and trademarks, protection 10 plus 5 years, covers 2D and 3D designs, Locarno classification used. Now under Layout Design Act 2000, protects semiconductor IC topographies, administered by Semiconductor Integrated Circuits Layout Design Registry. Protection, 10 years. Originality required, not purely functional. Aligns with TRIPS Agreement, Article 35 to 38. Reverse engineering for analysis allowed. And under International Framework, TRIPS Agreement, WTO, Articles 25 to 26, Designs, and 35 to 38, ICs, Paris Convention, Industrial Property, Hague Agreement, International Design Registration, Washington Treaty 1989, IC Topographies, WIPO administers global IP treaties, Locarno Agreement, Design Classification. So essentially, this slide gives us the Domestic Act, the Specialized Act, and the International Backbone all in one place. This brings us to registration process. Step 1, prepare application. Applicant files Form 1 with representations of the design, drawings or photographs, class of article, Locarno, and prescribed fee. Step 2, filing at the registry. Filed at the Patent Office in Kolkata HQ or branch offices. Can be filed online via IP India portal. Step 3, formal examination. Controller examines for formalities, novelty, originality, and not contrary to public order or morality. Step 4, objections or response. If objections raised, the applicant must respond within 3 months extendable. Meeting may be granted. Step 5, registration and publication. On acceptance, the design is registered and published in the Official Gazette, certificate issued. And Step 6, renewal. Initial protection, 10 years, can be renewed for 5 more years, total 15 years max, by filing Form 3. So that's 6 clean steps from application right through to renewal, a fairly straightforward administrative journey. Moving further, let's look at agricultural applications of design and layout rights. Under design rights in agriculture, novel shapes of agricultural tools, plows, sprayers, harvesters, ornamental design of seed packaging and containers, visual design of irrigation equipment and fittings, aesthetic configuration of greenhouse structures, design of pesticide or fertilizer dispensers, tractor body panels and implement designs. Now under layout design in agriculture, IC layouts in precision farming sensors, soil, moisture, pH, microcontrollers in automated irrigation systems, GPS chips for drone-based crop monitoring, biosensor chips for rapid plant disease detection, smart weather station integrated circuits, RFID chips for livestock tracking and management. And there's a nice summary line at the bottom. Both design and layout rights support the modernization of Indian agriculture through technology protection. This is one of those slides that really connects the legal theory to practical on-ground farming technology.
One more important concept is benefits of design and layout protection. The first benefit, exclusive commercial rights. Owner has exclusive right to apply the design to articles for sale, manufacture, or import. Second, market differentiation. Distinctive appearance helps products stand out in competitive agricultural markets. Third, licensing revenue. Registered designs can be licensed to third parties, generating royalty income. Fourth, investment protection. Protects R&D investment in developing innovative product appearances and IC layouts. Fifth, prevents copying. Legal deterrent against imitation of agricultural tools, equipment, and precision devices. And sixth, technology transfer. Facilitates technology transfer agreements in agricultural biotechnology and precision farming. So altogether, 6 clear benefits ranging from commercial exclusivity to enabling technology transfer.
Let's continue with infringement of design and layout rights. Under what constitutes infringement, the first act is applying a registered design or fraudulent imitation to any article for sale without the owner's consent. Second, importing any article bearing a registered design for sale without authorization. Third, publishing or exposing for sale an article with an infringing design. And fourth, for layout design, reproducing a protected layout or incorporating it in an IC without authorization. Now, under remedies available, civil suit for injunction and damages. Recovery of damages, $25,000 per infringement, Design Act. Seizure and destruction of infringing articles. Account of profits. Criminal prosecution, Layout Design Act. And under exceptions/permitted acts, private non-commercial use, experimental or analysis purposes, teaching and academic use, reverse engineering for analysis, layout design, acts done before registration date. This is a slide worth revisiting before your exams because infringement, remedies, and exceptions together form a complete answer on their own. Let's now explore case studies, semiconductor layout design protection. Take a look at the first one. Case 1. Brooktree Corp. versus Advanced Micro Devices, AMD, USA, 1992. Under background, Brooktree Corp. registered 2 MaskWorks, digital-to-analog converter chips, under the U.S. Semiconductor Chip Protection Act, SCPA, 1984. AMD reverse-engineered and produced functionally similar chips. Under legal issue, whether AMD's reverse engineering and copying of Brooktree's MaskWorks constituted infringement under the SCPA or was shielded by the reverse engineering for analysis exemption. Under outcome, jury ruled AMD's copying exceeded the reverse engineering defense, infringement confirmed. AMD ordered to pay $26.3 million in damages, the first and landmark SCPA infringement verdict. Under significance, established that SCPA maskwork protection is enforceable, clarified the limits of the reverse engineering exemption, set precedent for semiconductor layout IP globally. Now, Case 2, Intel Corp. versus NEC Corp. USA, ND Cal, 1989. Under background, Intel alleged NEC copied the microcode of its 8086-8088 microprocessors. NEC had licensed the architecture, but Intel claimed the specific layout or microcode expression was separately protectable separately from underlying. Under outcome and significance, court held that while microcode is copyrightable as a literary work, NEC independently created its microcode. Distinguished layout expression from functional architecture, a key boundary-setting ruling for ICIP. So these two cases together really show us how courts draw the line between fair reverse engineering and outright copying. This is genuinely one of the more important concepts in this chapter. Continuing with our case studies, Semiconductor Layout Design Protection continued. Case 3. VLSI Technology, LLC versus Intel Corporation, USA, FedCirc 2023. Under background, VLSI Technology, LLC, a patent assertion entity holding former Philips/NXP semiconductor IP, sued Intel alleging infringement of patents covering power management and chip speed layout techniques. Under legal issue,
whether Intel's microprocessor layout designs infringed specific claims on integrated circuit power delivery and frequency scaling topographies. Under outcome, in 2021, a Texas jury awarded VLSI $2.18 billion, one of the largest patent verdicts in U.S. history. The Federal Circuit largely affirmed in 2023, underscoring the high commercial value of IC layout IP. Now, Case 4, India, Semiconductor Integrated Circuits Layout Design Act 2000. Under context, India enacted the SICLDA Act 2000 in compliance with TRIPS Art 35-38 and the Washington Treaty on Intellectual Property Rights in respect of integrated circuits, IPIC Treaty 1989. A Semiconductor Integrated Circuits Layout Design Registry was established. Under key provision and impact, layout designs must be original and not commonplace. Protection lasts 10 years from registration or first commercial exploitation. The Act enables Indian semiconductor firms, example ISRO's VSSC, IIT's Chip Labs, to register and enforce IC topography rights domestically and seek reciprocal protection abroad. So notice how this last case actually brings us back home to India, showing us how our own legal framework fits into this global picture. Quite a nice way to close the case study discussion. Finally, let's discuss challenges, summary, and references. Under challenges, low awareness among farmers and SMEs, high cost of registration for small innovators, difficulty proving novelty for incremental designs, enforcement challenges in rural markets, rapid technological change outpacing legal frameworks. Under summary, design rights protect aesthetic features of agricultural products. Layout Design Act protects semiconductor IC topographies, both governed by national acts aligned with TRIPS. Registration is essential for enforcement, critical for precision farming innovation protection. And under references, the slide lists the sources used, including Urbish and Moradia's work on intellectual property rights in agricultural biotechnology, Ganguly's book on intellectual property rights, the Designs Act 2000, the Semiconductor Integrated Circuits Layout Design Act 2000, the Ministry of Agriculture's State of Indian Farmer Report, and the TRIPS Agreement of the WTO. If you found this lecture helpful, please like the video, subscribe to our channel, and share it with your friends. If you have any questions, feel free to leave them in the comments section. Thank you for watching, and I'll see you in the next lecture.